Okay. And this is Yee versus Formosa, Michigan LLC et al., docket number 20-597 CB. This is the time set for hearing on the defendant's motion to amend pleadings. And before I take your appearances, I would just indicate that this is the type of motion that really needs no more than 5 minutes can allow no more than 5 minutes of argument. And so I will limit you to that. I have read your papers that you filed, both the moving party and the response. So you can know that I have read that. So with that, I'll ask for appearances for the plaintiff first, please.
For the plaintiff, Your Honor? Okay, good afternoon, Your Honor. Alice Pike from Mark Ziello and Associates, representing the plaintiff.
Thank you. And for the defendant?
James R. Giddings, Your Honor, on behalf of defendant Formosa, Michigan, Chow Wan and Chu Wang Sahardia, I believe it is.
Okay. Okay, your motion, Mr. Giddings, you can go ahead.
Well, it's really a simple motion, Your Honor. Our motion is a motion to amend. This court just took up another motion that basically covered much of the same territory about a week ago. We filed a timely motion under the rules. Judge Stokes, in her pretrial statement, gave us until June 30th. We filed it then. And the motion's really governed by MCR 2.118 sub 2. It says what it says, and the case, which reflects longstanding Michigan law, is Ford Motor Company versus City of Woodhaven, 475 Michigan 425, which I cited. And that case overturned a denial of a request to amend pleadings. And in Ford Motor Company, the Supreme Court says the motion can only be denied for undue delay, bad faith, repeated failure to cure deficiencies, undue prejudice to the opposing party, or futility. We submit that nothing like that is present. The plaintiffs make many allegations that they claim are true. They make many statements about the defendant, which they disparage the defendant's position. I don't think that's the issue in this motion to amend. The question is, do we get a chance to go to court and prove our defenses? Thank you.
Thank you. Ms. Pike?
Yes, Your Honor. First of all, with regard of MCR 2.118 Section 2, we believe that justice would not require it here because the content of defendant's documents and their attached exhibits are already full of false and contradictory statements and information, and defendants are not likely to do otherwise, even if they are allowed to amend their pleadings. Secondly, with regard to Woodhaven case, we do not believe defendant's motion to amend should be granted because defendants have been acted in bad faith by filing documents and exhibits and providing evidence containing many false, misleading, contradicting statements and information, by making allegations without providing any supporting facts or evidence, by omitting certain critical parts of the evidence, and by making statements while completely disregard of the facts and evidence already provided by the plaintiff. Furthermore, we believe that allowing defendants to amend pleading will cause undue prejudice to our client. Defendants have been and are more than likely to continue to make false and frivolous claims against our client, which are baseless without any supporting facts and evidence, and are false and misleading. In addition, we believe that allowing defendants to amend pleadings would be futile. It would not be helpful or useful to the case because as defendants already did, defendants would still fail to respond most of the questions and critical points raised by the plaintiff. We therefore conclude that defendants should not be allowed to amend their pleading. If this court so desire, we will further proceed to provide some examples to support our arguments above. Shall we do that, Your Honor?
I don't think I need that in order to rule on this motion, but thank you very much.
Thank you.
Okay, so this was anything but by the rules because Judge Stokes might have given the defendants until June 30th, but on June 30th, the defendants filed a motion to amend pleadings that was 1 page and stated as follows. Now come defendants and present their motion to amend pleadings. And then the brief came 2 days before this hearing on July 12th. Which was the notice of submission of authorities bearing on the defendant's motion to amend. But be that as it may, it is a rather straightforward and uncomplicated matter to rule on. I do question why I even have to, because I granted leave to file the plaintiff's second amended complaint. The defendants have to file an answer to that. So it seems to me they could have filed a counterclaim then, but be that as it may, these types of amendments should be freely granted. There is a reason upon which it could be denied, and that would be futility. It appears that that the plaintiff is arguing futility. In their response, they say the defendants fail to state a claim upon which relief can be granted. But that's not really, that would be a futility argument, but then they go on to say that the defendants' claims are false, there's no evidence to support them, they're frivolous, they're baseless, and they're not proven. That's not only not the standard for failure to state a claim, it's also not the standard for futility. Futility is like a C8 motion. If you can show as a matter of law that the amendment can't succeed, then it's futile. But to say that it can't be proven or there's no facts, that's totally premature, and that's not a basis upon which to find futility or that a claim fails as a matter of law. So I am granting the defendant's motion to amend the pleadings, which is to file a counterclaim. I would note that defendants already filed it back on June 30th as a separate document, which shouldn't have happened. It should have been attached to their motion, but it was filed as a separate document. But in any event, that's fine. The defendants have leave to file their counterclaim.
May I comment, Your Honor, briefly? Jim Giddings. Yeah,
What?
Those documents should have been filed together, and we apologize for that because it was not entitled to be filed. It was absolutely done improperly, I agree. And we can refile it if you believe that's necessary.
Well, I think you're going to have to refile it because you haven't had leave to file it until now. So I think you're going to have to refile it and establish the time frame in which to serve and answer it. So I mean, I'm not trying to be overly critical. I'm just trying to get things on a better track in the future as far as the court rules go.